The court judgment revealed that when Steve Jobs came back in 1997, in one of the earliest meetings, a senior manager was taking notes, writing down what Jobs was saying about Apple's new innovation. Jobs suddenly stopped and said to the manager, "Why are you writing this down?" The manager said, "I'm taking notes on what you said." Jobs then said, "If you are not smart enough to remember this, you shouldn't be in this meeting." From that point onwards, Apple's executive members all stopped taking notes. This is Apple's verbal culture during its early ages. It's not a made-up story. It is the evidence given by Mr. Philip Schiller, Apple's former senior vice president of worldwide marketing and late Apple fellow. He played a central role in Apple's store policy. In Epic Games and Apple, his evidence was central to explaining why Apple banned alternative app stores, why sideloading, which refers to the process of installing apps onto iPhones from other sources, was prohibited, and why in-app purchase was mandatory for digital contents on Apple Store. Mr. Schiller's evidence also revealed the secrets of how Jobs ran the company and the goal of Apple's ecosystem. Even Steve Jobs may never have expected that the verbal culture he cultivated would harm Apple's lawsuit in court 30 years later. No doubt that Apple Store has transformed the world. Developers are lining up to build apps. Consumers are raving about their online shopping experience. Apple says, "We created this ecosystem for security, privacy, and user trust," and Apple also made tons of money. But behind the scenes, who was actually making the decisions? How were they made? And why did a federal court judge in 2025 said he was not persuaded that Apple's restrictive model was primarily about security? And perhaps the most interesting question of all, what role did Steve Jobs, the architect of Apple's philosophy, play in shaping a system that later became the centerpiece of a global competition case? Today, we are not just discussing legal principles. We are dissecting Apple's internal decision-making culture and corporate governance, and how that practice influenced the outcome of one of Australia's most significant digital market judgments. Before there were courtrooms, there was a philosophy. Apple's iOS ecosystem was designed as a closed, centrally controlled platform. Apps could only be installed through the Apple Store. Payments from digital content had to go through Apple's in-app purchase system. Apple's narrative has always been security, privacy, user safety, and seamless integration. But in Epic Games versus Apple case, as Justice Jonathan Beach observed, the question was not whether security was relevant, it was whether security was the true dominant purpose behind the restrictions. The court had to examine how Apple actually made decisions, and that takes us into Apple's internal culture. You cannot understand Apple's cultural legacy without understanding Steve Jobs. Although Jobs passed away in 2011, his influence shaped the DNA of iOS. Evidence referenced in the judgment shows Jobs strongly advocated full end-to-end control, centralized distribution, no fragmentation, and no sideloading. In internal communications, Jobs described sideloading as something that would create a real mess. And it was explicitly said by Jobs that if he had a choice, he would like to kick Amazon, Netflix, and others out of Apple's products. On 24 October 2010, Jobs sent an email to his executive team in which he made clear that an objective of Apple in 2011 was to tie all of our products together so we further lock customers into our ecosystem and make Apple ecosystem even more sticky. Although Apple's witness, Mr. Craig Federighi, testified that the word sticky was used to mean that users love Apple products, court interpreted it as erecting barriers to user switching so that users can't afford to leave it. A key example is the iMessage app. It is not available on Android devices. Have you wondered why? It's not that technically iMessage couldn't be used on Android. It's because Apple won't allow it. This is evident that on 3rd March 2016, Mr. Philip Schiller emailed Mr. Tim Cook saying, "Moving iMessage to Android will hurt us more than help us." Apple tried to picture the story that control was embedded in Apple's design philosophy from inception. The Apple Store model reflected Apple's view that integration equals quality. But here's the turning point. The court did not find that Apple's control philosophy automatically amounted to a security necessity. Justice Beach accepted security as a factor, but rejected the idea that it justified eliminating competition. The court recognized Apple's design ethos, but it was also recognized that once Apple achieved substantial market power in iOS distribution, the same philosophy could produce anti-competitive effects. Philosophy is not immunity. What happens when one of the world's most powerful companies doesn't keep detailed written records of key strategic decisions? Mr. Philip Schiller and Mr. Craig Federighi are the two senior executives that give evidence in court. Mr. Schiller said this to the court: "I was a member of the leadership team at every stage of development of the iPhone, from its concept through its development and its production. And so I had a role in all elements of the creation of the iPhone, the hardware and the software, and had an input to many of the decisions of features implementation, and then that carried through to launching the iPhone." Mr. Federighi, on the other hand, has been the leader of software engineering team since 2009. Based on the court documents, a decision-making body within Apple is the executive team. The executive team comprises of the heads of each functional organization within Apple, including the CEO, CFO, heads of services, head of manufacturing and operations, head of sales, chief legal counsel, head of software engineering, head of hardware engineering, and at times, head of support. But the key decisions relating to Apple's innovation were made by a subset of executives. According to Mr. Schiller, there are a few stages of that small group. Before 2011, himself and Mr. Jobs were the members. In 2012, after Jobs passed away, Mr. Eddie Q and Mr. Scott Forstall are the decision makers. After 2012, the executive members were Mr. Tim Cook as the CEO, Mr. Luca Maestri as the CFO, who were replaced by Kevin Parak, and Ms. Catherine Adams as the general counsel, who were recently replaced by Jennifer Newstead. The executive team generally meets each Monday for 3 hours to discuss the strategy and direction of the company, as well as ongoing programs that Apple is running. Mr. Schiller gave evidence that from around 2007, he had reported directly to the CEO, who in turn reports to Apple's board of directors. It is the CEO's responsibility to work with the board on their agenda and told the board about features of a product. This is peculiar because according to Mr. Schiller's evidence, most of the members in the executive team and the board members don't talk to each other. The executive team was actually unaware of matters raised with Apple board. Neither did the executive team report to the board. For example, the decisions associated with restrictions on third-party developers on Apple Store were mainly dictated by the executive team itself because they were considered important but not strategic for Apple. Even Mr. Schiller was unaware of those key decisions regarding the Apple Store were ever communicated to the board. On one hand, it is bizarre that the board members were not being involved in important decisions such as Apple Store's development, especially at the time Apple was a far smaller business than it is today. On the other hand, it manifests that Apple has a very effective executive team and pushes through new innovation with great discretion. Another explanation, as you might have thought about, is that Apple certainly didn't want to admit that board members were involved in decision-making so that they might be called as witnesses to give evidence in court. It's the executives that should do the heavy lifting and show themselves before the camera. Fair enough. Now turning to Jobs' management style. That is, everyone should be able to listen, absorb, and retell information without depending on handwritten notes. But this, as mentioned by the court, does contextualize Apple's approach to decision-making, which was dynamic and highly effective. In court hearing, Mr. Federighi said this: "Apple has a culture of its employees that often stay a very long time, 15, 20, 30 years. We have a very verbal culture. We have a lot of shared understanding. But the problem is that for Apple's size, making important decisions without meeting minutes or records brought great risk to corporate governance. Not only there were no meeting minutes, for many key decisions, there were no cost analysis, capital investment analysis, or financial measures such as forecast cash flows and investigation reports of what stream of revenue will be produced for Apple. The court did not appreciate that Mr. Schiller attempted to downplay the significance of these decision-making during cross-examination. In competition cases, courts often infer purpose from contemporaneous documents, and here, the documentary trail was thin. Apple said, if you open the system, you compromise security. Both Mr. Schiller and Mr. Federighi give evidence in court, and they maintained that Apple's store model was designed to protect users. Centralized review reduced malware. Alternative payment systems introduced fraud risks. Sideloading would undermine trust. The court looked beyond assertions and responded, "Show me the evidence." But it was the written evidence that Apple did not have. Court examined internal documents, timing of policy development, whether alternative models were meaningfully evaluated, and whether less restrictive alternatives were considered. The court found that some of Apple's most formative and significant Apple Store and in-app purchase decisions were informal in character. Such decisions, as previously mentioned, were often made by a subset of the executive team, and in some instances were not even made or discussed at an executive team meeting. Instead, decisions were often just made by a small group of the Apple executives who were responsible for the relevant area. For example, it transpired that Jobs, Schiller, and Forstall permitted third-party developers to develop apps on the iPhone, and Jobs, Schiller, and Q then permitted 30% commission rate for in-apps purchases. The judge noted that there was a lack of documentary evidence showing that Apple undertook structured competition impact analysis when maintaining bans on sideloading, alternative app stores, and alternative payment mechanisms. This absence mattered. Although Mr. Schiller kept telling the court that he did not need a document to remember that Apple did put a lot of weight on security concerns, the court considered that it was impossible for Mr. Schiller to still remember all details discussed almost 30 years ago. More likely than not, he just put those memories together to make it sound in favor of Apple. The judge did not believe everything Mr. Schiller said, especially when he seemed to forget many details of key decision-making process, but only remembered details that helped advance Apple's case. For example, it transpired that Mr. Schiller did not know how much money it would make from the Apple Store back in 2008, and he only remembered that Apple hoped it would break even. Mr. Schiller could not recall any documentation to reduce commission for subscription in 2016. Mr. Schiller could not recall any documentation to introduce the multi-platform room in 2018, and reason for that decision. Mr. Federighi also spoke about the threat for iOS without referring to any documents at all, and the court found his understanding was all retrospective and based on verbal discussions with others. When it came to limited documentation or public narratives suggesting that Apple's iOS was truly driven by security and privacy concerns, Justice Beach noted that those were articulated more forcefully in later years, after regulatory and legal scrutiny increased worldwide. For example, in 2019, Apple's public relations teams published an Apple Store story. This article alleged that our goals from day one was to create a safe and trusted place for customers and give all developers an equal opportunity to succeed. The timing of that story was important. Critics at the time had accused Apple of extracting 30% commissions, excluding rival app stores, blocking payment competition. Justice Beach accepted that centralized system can enhance security, and Apple genuinely values security. But he made several critical observations. Number one, many security protections operate at OS level, being independent of distribution channel. Number two, Apple already allows third-party payment systems for physical goods, but not for digital contents. Number three, Android allowed sideloading yet maintains substantial security protections. Number four, there was insufficient documented analysis demonstrating that competition-friendly alternatives were fully assessed. This led to a crucial judicial skepticism. If security were truly the sole driver, why were similar restrictions not applied uniformly? The court was not persuaded that the restrictive ecosystem was originally designed primarily as a competition-neutral security mechanism. As a result, Justice Beach found Apple had substantial market power in the iOS app distribution market. Apple has substantial market power in the iOS in-app payment solutions market, and the bans on sideloading and alternative payment mechanisms had the purpose or effect of substantially lessening competition. Importantly, even if Apple partly pursued security, that did not negate anti-competitive purpose or effect. The lack of transparent decision-making records weakened Apple's ability to demonstrate that its restrictions were strictly necessary or proportionate. In competition cases, unexplained power invites judicial intervention. We have discussed the Justice Beach's reasoning and legal battles between Epic Games and Apple in details in another video. You can check if that interests you. This case wasn't only about apps. It was about how corporate philosophy, shaped by visionary founders like Steve Jobs, can evolve into structural market power. A lack of decision-making records, such as minutes of meeting, could harm significantly the credibility of one's story based on retrospective memories. Apple built a beautiful, secure, tightly controlled ecosystem, but the digital economy is no longer the Wild West. In Australia, in particular, there would be increased ACCC scrutiny of digital platforms and greater openness mandates similar to EU Digital Markets Act. So here's the question for you. Was Apple's walled garden built to protect users or to protect control? And if both, where should the law draw the boundary? Because in the digital age, the real competition is not over apps, it is over who controls the platform. Thanks for watching. If you would like to have more legal explainers in depth, like, subscribe, and share. I will see you next time.